Fair Value in the BVI, Guidance on Property Valuation and Minority Discounts from Ming v. JF Ming Inc. The decision of Justice Mangatal in Ming v. JF Ming Inc. is the latest judgment from the long-running family dispute and unfair prejudice proceedings over JF Ming Inc., JFM, a BVI holding company with subsidiaries holding substantial real estate in Hong Kong. The judgment is notable as it is the first detailed BVI decision that deals with the valuation of real estate holding companies in Hong Kong in unfair prejudice proceedings and the question of whether a minority discount should be applied in a non-quasi-partnership case. Procedural history. In 2014, the claimants, 3 of 7 siblings, jointly commenced unfair prejudice proceedings against their brother, Lawrence, and JFM. The proceedings were bifurcated and structured in phases. In 2016, the BVI Court found in favour of the claimants on all aspects of their claim and granted them the relief sought, including a buyout. On appeal by Lawrence, in 2017 the Eastern Caribbean Court of Appeal set aside the buyout order but otherwise upheld all findings of Lawrence's unfairly prejudicial conduct and the other discrete remedies granted to the claimants. In 2021, the claimants appealed successfully to the Privy Council, which reinstated the buyout order, concluding the liability phase of proceedings. See our blog on the judgment here. In 2022, at the first stage of the valuation phase, the BVI Court, I, fixed the valuation date, 2, determined the share entitlement of each claimant, and 3, decided that certain contested claims should be excluded as assets of JFM for the purpose of valuing JFM's shares. Issues for determination. The matter then proceeded to trial before Justice Mangatal, where the principal issue for determination was the fair value of the claimant's shares as at the valuation date. The court was concerned with 2 main issues: first, which expert's valuation was to be preferred, and second, whether a minority discount should be applied in valuing the claimant's shareholdings. Property valuation methodology. On the first issue, both share valuation and property valuation experts were instructed, but by the time of trial the only dispute concerned the property valuations of Kyoto Plaza, the most valuable real estate in JFM's portfolio. The experts adopted different methodologies, leading to differing valuations. The claimant's expert relied primarily on an income approach, with a market approach used as a cross-check, producing valuations of 1.44 billion Hong Kong dollars, income approach, and 1.40 billion Hong Kong dollars, market approach. Lawrence's expert, by contrast, relied exclusively on the market approach and arrived at a lower valuation of 1.27 billion Hong Kong dollars. The claimants argued that Lawrence's expert erred in failing to apply the income approach or, at the very least, an alternative method as a cross-check. They contended that best practice, informed by the International Valuation Standards, IVS, required the income approach where the property's critical attribute was its income-generating ability from a market participant perspective. Lawrence disagreed, arguing that in Hong Kong commercial real estate is valued both for capital appreciation and income generation, such that the income-producing ability of Kyoto Plaza was not a critical element, and therefore did not mandate the application of the income approach. Lawrence also argued that there were insufficient reliable rental comparables to support a meaningful income approach adopted by the claimants. The difference between the experts' market approach valuations turned largely on their treatment of ground floor units, in particular a unit with an unusual layout, and their selection of comparables and adjustments for factors such as location and age. Ultimately, the court preferred the evidence of the claimant's expert, finding that it better complied with the IVS, particularly IVS 105, which emphasizes the income approach for income-generating properties. In doing so, the court implicitly accepted, without elaboration, that Kyoto Plaza's income-producing potential was a critical element of its value, thus justifying the application of the income approach. While the court accepted the primacy of the income approach, the judgment does not contain any detailed technical explanation of how the claimant's expert applied the income approach, e.g. rent assumptions or yield selection, or why the court was satisfied that reliable rental comparables existed to support the claimant's income approach despite Lawrence's objections. Minority discount. The second issue concerned whether a minority discount should be applied. The parties agreed that there was no prior BVI authority and that the court could adopt either the obiter approach in Strahan v. Wilcock, which suggests a minority discount should ordinarily apply unless exceptional circumstances exist, or the approach in a line of English first instance authorities holding that there is no presumption in favour of a discount. Justice Mangatal accepted the claimant's submissions that a presumption of discount would reward the wrongdoer and incentivize oppressive conduct. She held that 1. Even in non-quasi-partnership cases, the general rule is that no minority discount should be applied. 2. It is only in exceptional cases that such a discount should be brought into play, and 3. That such circumstances might include cases where the minority shareholder acquired the shares at a discount, or otherwise acted in a manner justifying their exclusion from the company. On the facts, the court found that the long-standing non-payment of dividends since 1994 pointed strongly against applying any discount, and therefore valued the shares on a pro rata basis. Takeaways. Primacy of the income approach to property valuation. The court held that where a property's value lies in its income-producing potential, the international standard, namely, IVS 105, requires application of the income approach. Experts who fail to use it, or at least to deploy it as a cross-check, risk having their evidence rejected. No minority discount save in exceptional cases. The court confirmed that even in non-quasi-partnership cases, there is no general presumption in favor of a minority discount. Such discounts will be confined to rare cases, such as shares acquired at a discount, with the default position being full pro rata valuation. Consistency with Commonwealth case law. The court noted that its ruling against the presumption of a minority discount was in line with numerous Commonwealth authorities.